Call on members. Order of the day number 3.
Keep Kiwibank Bill, second reading.
Mr Speaker.
The Honourable David Parker.
Mr Speaker, I move that the Keep Kiwibank Bill be now read a second time. Mr Speaker, I want to recount the history to this bill, which was introduced by my colleague, the Honourable Clayton Cosgrove. The background to the bill was that the government had sold roughly half of the major electricity companies to private investors, and didn't need to have recourse to Parliament to make that sale, because there was nothing enshrined in legislation that required parliamentary approval to the sale of publicly owned institutions or shares in these publicly owned institutions like those generators. So Clayton Cosgrove brought to this House a bill that said, well, parliamentary approval ought to be required if a future government wants to sell Kiwibank. It is our only significant bank competing against foreign banks in the New Zealand market. There are some others, but they're not very big when it comes to taking on the dominant banks from Australia. There was parliamentary support for the piece of legislation to go to Select Committee, and to Select Committee it went. At Select Committee, and one of the reasons why I think opposition parties and some of the other parties supported the legislation was that the government was saying, well, they had no intention of selling Kiwibank anyway, so they thought, we'll keep the government honest by putting a piece of legislation that says you've got to get parliamentary approval before you sell Kiwibank. Now, when the bill got to Select Committee, it became apparent that the mechanism that was proposed in the bill, which was to require a supermajority, which is more than just a bare 50% vote plus one in the Parliament in support. It wanted a supermajority, and that was perhaps a step too far, requiring a supermajority being reserved for important things like reforms to electoral law. Clayton Cosgrove and the other members on behalf of the Labour Party agreed with those propositions and said, well, we should change the bill so it requires a bare majority of Parliament before Kiwibank can be sold, but nonetheless requires parliamentary approval. The National Party used their numbers on the Select Committee to block those amendments being made and have referred the bill back to Parliament without those amendments being incorporated. At about that time, Kiwibank decided that it wanted to raise more capital. Kiwibank was created at a time when New Zealand Post was a much larger organisation, when there was a lot more mail, and it could be supported by New Zealand Post in part for its expansion plans. Because postal volumes have dropped by 80%, New Zealand Post is no longer in a position to provide additional capital to Kiwibank to expand. The government has refused to give Kiwibank additional capital, so the board of Kiwibank have found an alternative mechanism to raise more capital, which is to sell some shares to some government-owned entities, being ACC and the New Zealand Superannuation Fund. A good idea. We support that in the circumstances that New Zealand Post face. But of course, the effect of that is that unless there's some protection around that share sale, those organisations can on-sell those shares without recourse to Parliament, and through that sale, effectively in the future, those shares could be privatised. We have a supplementary order paper which has already been tabled in this House, which changes this bill so that parliamentary authority is required for any future sale of Kiwibank shares, that sales to Crown-owned entities are allowed, but only if there is a first right of refusal to the Crown to purchase those shares back from the entities that it owns anyway, if those entities are to sell, and the requirement that the Crown exercise that first right of refusal, because otherwise you can't effectively stop these shares being privatised in the future without further recourse to Parliament. So that is the effect of this bill. And we hope that we will gain support for this bill from other members in Parliament so that democracy has its say in respect of whether the only large or significant banking institution in government ownership cannot be sold at the whim of a government but rather requires a parliamentary majority to authorise that sale. That, sir, is in a nutshell of what this bill does. The supplementary order paper has been available for a long time for people to consider, and I know that other political parties have given it due consideration. And, sir, we'll know in an hour or two whether we have the votes for this piece of legislation to pass second reading, so that the supplementary order paper can then be considered at the committee stage of the House, sir. I would make another point in respect of the unwillingness of the government to try and to improve this bill at Select Committee. Michael Woodhouse, in a contribution last Thursday, criticised opposition members for not having made changes to the Easter trading legislation that he thought were necessary at Select Committee. This is another instance of where Select Committees could have improved a bill, but because of this politicisation of it on this occasion by the National Party members, they refused to do so at Select Committee. It can still, of course, be done by this House, because it is in the end Parliament that decides whether legislation should proceed or not Select Committees. And on that basis, sir, I am urging other political parties in this House to consider the the Select Committee, the supplementary order paper that I've already tabled and has been considered by members, and to pass this legislation, so that in the future, if someone wants to privatise Kiwibank, they've got to get parliamentary authority. It does not block the sale of the shares and the capital raising presently underway in respect of ACC and the New Zealand Superannuation Fund. I know that to be the case. I've checked that, Mr. Speaker, and on that basis, sir, I think that the House should support it. I do think that given that the National Party has said that they're not going to sell Kiwibank, that's their promise that they have made the New Zealand electorate, that they should have no objection to passing this piece of legislation, which ensures that that principle is in place, and that any future government that wants to change that status quo just has to come to this House, get a bare parliamentary majority to change this legislation or to authorise the sale, and they'll be right. If they can't get that parliamentary majority, then they ought not to sell Kiwibank. It is one of those important New Zealand institutions that ought not to be able to be done away with at the whim of a government that perhaps was trying to achieve other purposes and didn't want to come to Parliament for the tick-off of Parliament before that happened. So, Mr. Speaker, the earlier impediment in this legislation to support from some parties, which was that the supermajority was inappropriate for this sort of legislation, is dealt with by the supplementary order paper that I have tabled. Clayton Cosgrove and the other members of the parliamentary team on the Select Committee agreed that that was appropriate, that we should just have a bare majority needed for this sort of authorisation. That is the effect of the supplementary order paper that lies on the table. The underlying effect then, sir, is that the Kiwibank bill places a restriction on the sale of Kiwibank to private interests, and effectively says that unless it's a sale to the Crown or to a Crown, for the Crown to sell its shares other than to a Crown-owned organisation, they need parliamentary approval, and if they are to sell it to a Crown-owned organisation, it has to be subject to a first right of refusal in favour of the Crown that the Crown must exercise if it is triggered by the offer under that first right of refusal. The final thing I'll say, sir, is that first right of refusal has to cover not just the shares that are acquired by the Crown-owned entity like ACC or the super fund at the time of the original transaction, but if there are additional share issues to that organisation, for example, by further raising of capital, then that applies. Then the first right of refusal applies to those additional share allocations as well, so that at all times the Crown has the ability to reacquire those shares if they were otherwise to be sold to private interests.
The question is that the motion be agreed to. David Bennett.